Welcome back to the Judgment Files. Today we're diving into a case that's had such a huge impact. I mean, it's really reshaped how we think about rights and equality. We're talking about Obergefell v. Hodges, the 2015 Supreme Court decision. And one of you reached out specifically asking us to really dig into this. You wanted to understand what were the main arguments, right? What were the different perspectives on this whole issue of same-sex marriage? So that's our mission today, to unpack this complex ruling and try to, make it clear without throwing a bunch of legal jargon around.
Yeah, I think that's key, right? Because to really get a grasp on this, on where the court landed and why, we've got to look at a few things. We've got the majority opinion, obviously that's the court's final say. And we've got the syllabus, too, which gives a good summary of that holding. But what's super interesting here is that we also have these dissenting opinions, right? From Chief Justice Roberts, Justice Scalia, Justice Thomas, and Justice Alito, that gives us a complete picture. We see not just what won the day, but also where the justices really disagreed, and maybe even more importantly, why they disagree.
It's like seeing both sides of the coin, right? And at the heart of it all, Obergefell v. Hodges, this case, it tackled this super fundamental question stemming from the 14th Amendment. Does it require states to not only allow same-sex couples to get married, but to also recognize those marriages if they're legally done in another state? I mean, that's a big deal. And the people who brought this case to the court, the petitioners, a lot of them were same-sex couples who shared these incredibly moving personal stories that showed exactly how these state laws were affecting their lives, on a day-to-day basis. Think about James Obergefell. All he wanted was to be listed as the surviving spouse on his husband Arthur's death certificate after Arthur died. But Ohio law at that time, it wouldn't let him. It basically said they weren't legally connected, even in death.
It's powerful, right, to hear those personal stories. They make the impact of these laws so real, These weren't just theoretical legal arguments. They were about real hardship, real people.
Exactly. They brought that human element to the forefront. And, in the end, the majority of the court, they based their decision on these bedrock principles of the Constitution, specifically the rights to liberty and the right to equal protection. But it was a divided court. We can't forget that. And the justices who dissented, they brought up some seriously important points about, what the court's role should be, about how marriage has been defined traditionally, but what this ruling could mean for things like democracy and religious freedom.
Those are big questions, yeah.
Yeah.
This wasn't a slam dunk, not by any means.
Well, absolutely not. So let's dive into this, starting with the majority opinion. One of the first things they tackle is this whole history of marriage. They acknowledge right off the bat that historically, marriage has often been understood as this union between a man and a woman. I mean, that's true across many societies.
Right.
But then they kind of turn that on its head. They say, hold on, the history of marriage isn't static. It's not like this fixed thing. It's an institution that's changed, significantly over time.
Yeah, and that's a super important point they're making. They bring up examples like the decline of arranged marriages, where people didn't really have much say in who they married. And they talk about the end of coverture, that legal idea that a wife's legal identity was basically absorbed by her husband. These were big changes to how marriage actually worked, right? And the court argues that those changes, those evolutions, they actually made marriage stronger. They brought it more in line with the principles of individual freedom and equality.
I see what you're saying. It's like they're using the evolution of marriage to push back against the dissent's idea that marriage has this fixed, timeless definition. It's saying that, well, what makes a marriage valuable? What makes it worthy of recognition? That can change as society's understanding changes.
Exactly. It's about keeping up with the times, right? Recognizing that our values and understandings can evolve.
Okay, so building on that idea that marriage can change, the court then lays out these 4 core principles. These are principles that they say show why the fundamental right to marry, should apply equally to same-sex couples. So principle number 1 is individual autonomy. This is all about the right to make these deeply personal choices. And they argue that, the decision of who to marry, that's absolutely essential to individual liberty. They even bring up Loving v. Virginia. That's the 1967 case that struck down bans on interracial marriage. It's like they're saying, look, we've been here before. Marriage and liberty are intertwined.
Right. There's precedent. It's not like they're pulling this out of thin air.
Exactly. And the second principle they bring up is that marriage is so fundamental because it creates this unique, this incredibly important two-person union. They cite cases like Griswold v. Connecticut, the one about married couples and contraception, and Turner v. Safley, that one was about the marriage rights of prisoners. And they're using those cases to show that the court has a long history of recognizing the importance of intimate association, like deep connection between two people. And the majority is saying same-sex couples deserve that same right to a committed relationship. And it goes beyond, just saying that same-sex intimacy is okay, which is what Lawrence v. Texas did.
So they're building on that idea, right? The freedom to choose who you marry. It's tied to our fundamental liberty. And then they're saying, but it's more than that. It's about the unique bond of marriage itself.
Right. And the third principle is all about children and families. The court acknowledges straight up that many same-sex couples across the country are already raising kids. They're raising kids in loving homes, in stable homes. They even point out that the laws in many states that let gay and lesbian couples adopt, those laws already recognize that these couples can create supportive families.
It's a good point, right? They're addressing that head on, the argument that same-sex marriage will somehow hurt kids or change families for the worse.
Yeah.
They're saying, well, look, the laws in many states already acknowledge that same-sex couples can be great parents.
Yeah, it's like they're using the existing legal landscape to bolster their point. And the fourth principle they talk about is this idea that marriage is a cornerstone of our whole social and legal order. They bring up Maynard v. Hill, which is this case from way back in the late 1800s, to underline this. I mean, think about it. States have built so much around marriage, right? Taxes, inheritance laws, who gets to visit you in the hospital, who gets to make medical decisions for you, all of that.
It's woven into the fabric of our society.
Exactly. And the court is saying that when you deny same-sex couples access to those benefits, to those responsibilities, it's not just unfair, it's demeaning. And it creates all this instability for these families.
Yeah, it's like they're painting this picture of same-sex couples being shut out of one of the most basic institutions in our society. They're saying they're prevented from fully participating in the same way that opposite-sex couples can. They're denied that same level of security and recognition.
Mm-hmm.
And it's not just about some abstract legal concept. It has real-world consequences, legal protections, financial security, you name it.
Absolutely. So the majority goes on to dig into how the 14th Amendment's due process and equal protection clauses, how they're connected. They point to cases like Loving Again and Zablocki v. Redhale. That one was about restrictions on marriage for dads who were behind on child support. And they say, see, these two ideas, due process and equal protection, they're intertwined. They go hand in hand when it comes to protecting fundamental rights. And they're arguing that, as society changes, as our understanding evolves, we start to see inequalities in these basic institutions that maybe we didn't see before.
They even specifically mention how equal protection arguments have been used to get rid of inequalities based on sex within marriage, citing cases like Kirchberg v. Feenstra. And it's interesting, right? You've got due process, which is all about making sure there are fair procedures and that fundamental rights are protected. And then you've got equal protection, which is about making sure everyone's treated equally under the law without discrimination. And the court's saying that denying same-sex couples the right to marry, it violates both of these.
It's a violation on two fronts.
Exactly. And there's this bigger idea at play, too. They're saying that the Constitution's guarantees of liberty and equality, they're not stuck in time. They're not frozen. They're meaning how we apply them. It can change as society's understanding changes.
It's like a living document. Right.
Exactly.
Okay, and this understanding leads right to their main argument. Laws that keep same-sex couples from getting married, they're a burden on their liberty, and they go against their right to equal protection under the law. They really stress that this denial, it causes real harm. It treats gay and lesbian people with disrespect. It makes them seem less than. And that's especially true given, all the societal disapproval and discrimination they've faced throughout history.
Yeah, the majority's super clear about that. They're saying these laws are unequal at their core. They deny a whole group of people access to this fundamental right and all the benefits, the recognition that comes with it. It creates this second-class status that's baked right into the law.
And based on all that, the court reaches this big conclusion. The right to marry is a fundamental right. It's part of every individual's personal liberty. So under the 14th Amendment, you can't deny same-sex couples that right. They flat out say same-sex couples have the right to marry, and they overturn Baker v. Nelson, which was this earlier decision from 1972 that had held excluding same-sex couples from marriage.
Overturning Baker, that was huge, wasn't it?
Oh, yeah, no question. And they also address this argument that, the court should just wait, let the legislatures handle it, let there be more public debate at the state level. They acknowledge all that's happened, all the discussions, the lawsuits, the referendums on same-sex marriage. But they say, no, if people are being harmed because they're denied a fundamental right, you can't make them wait forever for lawmakers to catch up. They even compare it to Bowers v. Hardwick, that case that upheld criminalizing same-sex intimacy until Lawrence v. Texas overturned it. And they talk about how much pain, how much humiliation Bowers caused while it was still the law. It's like they're saying, we've seen this kind of delay before, and it caused real harm.
Right. And they don't stop there. They also address the argument that allowing same-sex marriage will somehow weaken or hurt the institution of marriage. They find that whole idea to be, well, kind of illogical. They basically say that how same-sex couples choose to get married, it doesn't affect the choices that opposite-sex couples make about marriage and parenthood.
Yeah, it's like saying one group's rights don't come at the expense of another group's rights.
Exactly. They're saying marriage is strong enough to accommodate different types of loving, committed relationships.
Right, right. And importantly, the majority also makes a point of addressing First Amendment protections. They make it clear that religions and individuals, they still have the freedom to teach and believe what they want about marriage.
Yeah, that was definitely them trying to address concerns about religious freedom right from the start. They're saying, look, our ruling doesn't interfere with people's right to believe and teach their religious doctrines, even if those doctrines have a different view of marriage than what we've decided here.
It's like trying to strike a balance,
Yes.
between these different rights and freedoms.
Exactly.
And then they get to this really crucial issue of recognizing out-of-state marriages. They're saying, okay, same-sex couples now have the right to marry in every state. So it makes no sense for a state to refuse to recognize a same-sex marriage that was legal in another state. I mean, it would create so much chaos and hardship for couples who might move between states.
Yeah, can you imagine the legal mess that would be?
Exactly. And then they end their opinion on this really powerful note. They talk about how profound marriage is, the love, the commitment, the sacrifice, the family that it creates. And they say that same-sex couples, they seek all of that. They deserve that same dignity under the law. It's a really human-centered way to end this whole legal argument,
Absolutely. They're bringing it back to the heart of the matter. But of course, there were those dissenting opinions.
Right. Let's get into those. Starting with Chief Justice Roberts. His main argument is all about judicial restraint. He believes the court's job is to interpret the law, to say what it is, not to decide what it should be. And he says the right to marry, as it's understood in the Constitution, it doesn't include the right to completely redefine what marriage means.
He puts a lot of weight on the traditional definition of marriage, one man and one woman. He says that definition has been around for centuries, across tons of different cultures. He doesn't think it's just some random thing. He sees it as rooted in these core purposes of marriage, like having kids and raising them in a stable family.
And he argues pretty strongly that what the majority did, it was overstepping. It was like they were making policy, not just interpreting the law. And he says their decision, it doesn't have a strong basis in the Constitution or in the court's own past decisions.
Yeah, he's especially concerned about how they use this idea of substantive due process. He compares it to that era of judicial policymaking that everyone criticizes, the Lochner era. Back then, the court was super active in striking down economic regulations, and people said they were just imposing their own views about economics. Roberts is saying the Obergefell majority is doing the same thing, but with social issues.
I get it. And he emphasizes that to be considered a fundamental right under due process, something has to be deeply rooted in our history and traditions. And he doesn't believe same-sex marriage meets that standard.
Exactly. And he goes on to differentiate the cases that the majority relied on. Cases like Loving and Zablocki and Turner. He says those cases were about who could access marriage as it was traditionally defined, not about changing the very definition of marriage to include same-sex couples.
Okay, so he's drawing a line there.
He is. And he rejects the arguments about privacy, too, the ones the petitioners made. He says they're not just asking to be left alone. They're asking for the government to recognize and validate their relationships.
So it's a matter of public recognition versus private choice.
Right. And he brings up some interesting concerns about what this decision could lead to in the future. Like, if you can overturn this core definition of marriage, one man and one woman, could you then overturn the idea that it has to be two people? Could it lead to, legalizing polygamy? And, He doesn't necessarily think polygamy is around the corner, but he's concerned about whether the reasoning the court used has clear boundaries.
Yeah, that slippery slope argument. It's like, where do you draw the line?
Exactly. And he also pushes back on the idea that denying same-sex marriage causes real legal harm. He sees that more as a philosophical argument, not a legal one based on the Constitution.
Okay, so it's like he's questioning the legal basis for that claim of harm. And, this raises a big question for our listeners, for everyone, really. What role should the Supreme Court have in these social issues? Should they be cautious, let the democratic process play out? Or should they step in and protect rights, even rights that aren't specifically spelled out in the Constitution?
That's a big one. And it gets to the heart of Roberts' dissent. He really believes that this whole issue should have been decided by the people, by their elected representatives. And he's also worried about religious liberty. What about people and institutions that have religious objections to same-sex marriage? He points out that a lot of the protections for religious freedom that were in state laws, they aren't automatically included in this nationwide ruling.
So he's worried about unintended consequences, right?
Yeah. And one last point he makes is that he thinks the majority unfairly portrays people who support the traditional definition of marriage as bigoted. He really pushes back against that.
Okay, so now let's move on to Justice Scalia. His dissent, it takes an even stronger, maybe even a harsher tone in criticizing the majority. He sees this decision as a real danger to democracy itself. He's saying the court went way beyond its role, that they basically undermined the people's right to govern themselves by creating these new liberties that weren't there before.
Yeah, he really doubles down on those concerns about judicial overreach. He emphasizes that historically, it's been the state's job to regulate domestic relations, including marriage. And he points out that when the 14th Amendment was ratified, every single state defined marriage as between a man and a woman.
So for him, it's about the original understanding, the historical context.
Exactly. And he really goes after the majority's idea of reasoned judgment. He sees it as basically giving the court unlimited power to decide what rights the 14th Amendment should protect, regardless of what people understood it to mean when it was ratified.
It's like he's saying they're just reading their own preferences into the Constitution.
He even calls it a naked judicial claim to legislative, indeed super legislative power, which is, pretty strong language. And then he points out that the Supreme Court, it's not exactly representative of the American people. 9 justices, unelected, serving for life, and they're making this huge social change. He questions whether they have the right to do that.
It's that tension between judicial power and democratic principles.
Right. And he even expresses doubt about whether the majority is right to think that their new insight is somehow better than thousands of years of human understanding and tradition. He's basically saying, who are you to think you know better? And he's really critical of their writing, too. He calls it pretentious, sometimes incoherent, and he suggests that it makes the court look bad.
It's like he's saying they're damaging the court's reputation.
Exactly.
Okay, so moving on to Justice Thomas. His dissent focuses a lot on substantive due process, which he thinks is a fundamentally flawed concept. He sees it as giving judges too much power, letting them make decisions that should be left to the people.
He highlights what he sees as the contradiction in the petitioner's arguments. They were against state constitutional amendments that protected the traditional definition of marriage because they said it took the issue away from the people. But then they're asking the court to do the same thing, to enshrine their definition of marriage in the federal Constitution.
So it's about who gets to decide, right? The people or the court?
Exactly. And he offers a really narrow definition of liberty as it's used in the due process clauses. He says it most likely meant freedom from physical restraint, based on Magna Carta and how it was interpreted.
Yeah.
He argues that liberty in this context means freedom from the government, not a right to get benefits or recognition from the government.
So he's drawing a distinction between freedom from something and a right to something.
Right. And he goes on to say that the cases about the right to marry, they've always been about stopping the government from interfering with marriage, not about forcing the government to recognize some new definition of marriage. He uses Loving as an example again, pointing out that it was about the state prosecuting people for getting married, not about denying them some new right.
Okay, so she's framing those precedents differently.
Yeah. And he also draws a clear line between laws defining marriage as between a man and a woman and those old laws against interracial marriage. He stresses that those anti-miscegenation laws were tied to racism, to slavery, to white supremacy. He's saying that's completely absent from the traditional definition of marriage, which he sees as being about promoting stable families for raising kids.
So he's saying you can't compare the two.
Right. And he rejects dignity as a basis for constitutional rights, too. He says there's no dignity clause in the Constitution, and that dignity is something we all have inherently, not something the government gives us. And like the other dissenters, he's concerned that the majority basically ignored the importance of the political process. He thinks they cut short the people's ability to consider the implications for religious liberty.
So he's worried about the process being rushed, not just the outcome. All right, last but not least, Justice Alito. His dissent emphasizes that this debate over how to define marriage, it belongs to the people, not the court. He says the Constitution doesn't answer the question of same-sex marriage, so it should be left to the states to decide.
And he criticizes the majority's definition of liberty. He calls it postmodern. And he says it goes against the idea that the Constitution only protects rights that are deeply rooted in our history and tradition, like in Glucksburg. And like the other dissenters, he says the right to same-sex marriage isn't one of those deeply rooted rights.
It's all about how you interpret those key words, like liberty.
Right. And Alito argues that the majority's equal protection argument, it hinges on this idea that the main purpose of marriage is the couple's happiness, not having kids. He sees that as a modern view. And he says states have the right to stick with the traditional understanding of marriage, especially since we don't know what the long-term consequences of redefining it will be.
So there's that caution again, right? Not rushing into something without understanding the full implications.
Exactly. And he's concerned about religious freedom, too, just like Roberts. He worries that people who hold traditional views on marriage based on their religion, they'll be labeled as bigots and discriminated against.
So it's that fear of backlash, of people being marginalized for their beliefs.
Yeah. And he ends by saying that this decision shows how attempts to limit the court's power have failed. He thinks a desire to achieve what the majority saw as a good outcome, it overshadowed proper interpretation of the Constitution. It's like he's saying they let their desire for a particular outcome cloud their judgment.
Wow, so there you have it, Obergefell v. Hodges. Not a simple case by any means. So many different perspectives, so many complex arguments. Let's take a step back now and think about what all this means for our listeners, for everyone really. This wasn't just about a yes or no answer. It was about fundamental disagreements. Disagreements about what rights really mean, about the role of the Supreme Court, about the history and the purpose of marriage, and about how we balance individual liberty with our democratic processes.
Yeah, it really gets to the core of some of the biggest questions we face as a society.
Absolutely. So the majority opinion, as we discussed, it established a nationwide right to same-sex marriage. It grounded that right in the 14th Amendment, in the principles of liberty and equality. They said denying same-sex couples the right to marry, it caused real harm, it treated them as less than.
But we also have to remember the dissenting opinions, right? Those justices, they raised some serious concerns. They saw it as the court overstepping its bounds, as redefining a fundamental institution, as potentially harming religious freedom and sidelining the democratic process. They had a different view of liberty, a view more rooted in history and tradition.
It's like two different visions of how the Constitution should be interpreted, how our society should evolve.
And what really stands out, I think, is this tension between how our understanding of rights and freedoms is changing and how we interpret the Constitution, especially the role of history and tradition. This case, it shows just how much legal decisions can affect people's lives, how they can reshape our society. And it's still fueling debates about how far those constitutional rights should go, how they apply in a world that's constantly changing.
Yeah, this deep dive into Obergefell, it gives us the tools, the knowledge to understand those debates about equality, about religious freedom, about what it means to have fundamental rights. It makes us think about whose interpretation of liberty and equality should win out and how we as a society should go about making these big changes.
Hopefully this discussion has helped to clarify some of those complexities for our listeners.
We hope so. And we really encourage you, our listeners, to think about these arguments, maybe even read the court's opinions yourselves. What parts resonated with you? What questions are you left with? This case, it shows us how dynamic the law is, how connected it is to our lives. It's an invitation to keep thinking, keep learning.
Absolutely. We'll see you next time on The Judgment Files.